Hello, my name is John Snow, and I'm an attorney with the law firm of Parsons, Bailey, and Latimer. We have various offices in the western states. And what I do for a living is litigation, and a significant portion of the litigation I do is related to construction litigation. And as a result, I regularly end up reviewing construction contracts in a litigation context. However, I also will review contracts for a contractor because the same kind of issues seem to come up frequently, and you can, even as a litigator, you can somewhat catch some of the issues. I don't draft, I leave that for real lawyers, but I do review contracts and look for specific issues that may arise in a construction contract. And then with the experience with litigation, you kind of learn what is and is not going to be an issue as far as litigation goes. And because this presentation is called Construction Risk Shifting Through Indemnification and Insurance, this is particularly oriented to litigation because of indemnification and insurance generally being related to litigation. So I know I have the background to perhaps provide some insights to people regarding risk shifting in construction contracts. So to get started, all contracts are basically risk shifting. Even if it's how you're going to get paid, there's a risk shifting in that. For example, a pay to be paid provision saying that the general contractor doesn't pay the subs unless the general contractor is paid. That's shifting the financial risk from the general contractor to the subcontractors. So basically all contracts are doing is shifting risk, or even the scope of the work is a risk shifting device. But one of the specific things in construction contracts, because it seems to occur on a regular basis, is shifting the risk related to liabilities, not only just breach of contract liabilities, but also tort liabilities. For example, if somebody is injured on a project, who is going to be responsible for that injury? The property owner, the owner of the project, the general contractor who was responsible for the safety of the entire project, the subcontractor which created the hazard, or the supplier who provided the defective equipment. We don't know, and you don't know. And so you end up having litigation between four parties just to determine who has liability ultimately to the injured party. One of the ways that is the complexity of that relationship is reduced, or the uncertainty of that relationship is reduced, is to include in a construction contract such things as risk shifting through indemnification and insurance. And frequently, generally, you will see indemnification and insurance going hand in glove. And there's a reason for that. And one of the reasons is the indemnification isn't worth much if the party giving the indemnification doesn't have the financial capability of fulfilling its contractual obligations of indemnification. So those are some of the things to consider when you're drafting a contract or litigating a contract, is what are the indemnification and insurance provisions. Indemnification is actually a common law concept, but common law indemnification, as you can see from the case that's cited here, the Duffing versus County of Essex case, that the predicate for common law indemnification is vicarious liability without any fault attributable to the party to be indemnified or the indemnity. For example, if the subcontractor were the one to cause the condition that resulted in injury, but the general is liable because it was supervising the subcontractor, then the general contractor would have an indemnification claim against the wrongdoer, which would be the subcontractor. However, one of the defenses that frequently arise in those kinds of common law indemnification claims is that the general contractor had an obligation of supervision and was in a position to correct the condition that caused the injury to the third party. And as a result, common law indemnification may not apply. but the standard is high to get common law indemnification.